All right, in the next few weeks we're going to talk about contracts. In Chapter 7 we're going to focus in on the first two elements of contracts, agreement and consideration. Contract law is based on the common law, which we've talked about already, except for contracts for the sale of goods, which are governed by statutory law, specifically the Uniform Commercial Code, or the UCC. The idea is that they would provide stability and predictability for our commerce. A contract is a promise or set of promises for a breach of which the law provides a remedy, or the performance of which the law in some way recognizes as a duty. The objective theory of contracts is applied by the court, and it looks to the circumstances to determine the intent of the parties. Rather, it looks at the objective facts, and including what a party may have said when entering into the contract, how the party acted or appeared, and circumstances surrounding the transaction. To have a valid, enforceable contract, you need an agreement, which consists of an offer and acceptance, consideration, which is a bargain for exchange, something of value, contractual capacity, and legality. Legality has to do with the purpose of the contract. It has to be legal at the time of execution. There are a couple defenses up front to enforceability of a contract. Voluntary consent. In other words, a person shouldn't be forced to enter into a contract, as well as the form. Some contracts have to be in writing under the statute of frauds, which we'll talk about more later on. There are different types of contracts. A bilateral contract is a promise for a promise. The only thing that the offeree has to do to form the contract is to make a promise to perform. In a unilateral contract, the only way the offeree can accept the offer is by doing the act that was requested in the offer. In other words, a unilateral contract is a promise for an act. Formal versus informal contracts. A formal contract is a contract that has to be in writing to be enforceable. All other contracts are informal. Express versus implied. Express means expressed in words, orally or written, and implied means circumstances imply that there is a contract. Basically, requirements are that the plaintiff furnished goods or services, expected to be paid, and the defendant had a chance to reject those goods or services but didn't. Executed versus executory contracts. An executed contract is where all the parties have done everything they're supposed to. In an executory contract, at least one of the parties hasn't done at least one thing. Talk about the 3 V's, valid, void, and voidable. A valid contract is an agreement, consideration, contractual capacity, and legality. In other words, a valid contract has all 4 elements of a contract. A void contract is really an oxymoron in that it's not a contract to start with. An avoidable contract is an unenforceable contract. It's a contract that's valid to start with, but one or both of the parties could back out of it. Basically, in an example, that would be a valid contract that a minor enters into, and so therefore the minor could avoid it, or that would be a voidable contract. Quasi-contract, or contracts implied in law, is that you're going to see this when there is no actual contract. It's an equitable remedy, which we've talked about earlier in the semester. It's designed to prevent unjust enrichment by one of the parties. One example would be if there was not a contract, but somebody expected to get paid for their services, then they would get compensated in quantum merit. In other words, they'd get the reasonable value of their services. There are limitations. For example, if the other party was enriched, but it was for some unnecessary reason, neglect, misconduct. If, for example, if I provided something to another party that they didn't ask for and they didn't have an opportunity to reject, that wouldn't mean they necessarily are forced to pay for it. Let's focus in on the element of agreement. As we said earlier, that's offer and acceptance. The requirements for an offer are a serious intent, definiteness, and communication of the offer from the offeror to the offeree. In terms of intent, a contract is judged by what a reasonable person in the offeree's position would conclude about the offer. And here are some things that are not offers. Expressions of opinion. A statement of some future intent to enter into a contract is not an offer. Preliminary negotiations or invitations to negotiate, and advertisements. Typically, for example, if I advertise to sell my truck and 100 people responded, I wouldn't be bound to sell it to all of them. It would be an invitation for them to negotiate. An agreement to agree can, under the modern view, be enforceable if the parties intended to be bound. A preliminary agreement can be binding if the parties had agreed upon all the essential terms. The offer has to be definite. The terms expressed or implied need to identify the party, the object of the contract, consideration to be paid, and things like the time of payment, delivery, performance. An offer can require specific terms to make the contract definite, and a court can supply missing terms if the parties intend to form a contract. The offer needs to be communicated to the offeree. The offeree's knowledge of the offer can be either direct or through an agent. And an offer is terminated by the actions of the parties or by operation of law. One of the things that offeror could do is revoke the offer. And the offer can be withdrawn any time prior to the acceptance unless it's irrevocable. And typically the offer is effective when the offeree or the offeree's agent receives it. More under termination by action of the offeree could reject the offer, and that would be either express or implied. The offer could be terminated by a rejection and counteroffer. So if somebody offered to sell you something for $100 and you responded, I wouldn't pay more than $50, that would be a rejection and potentially a counteroffer. Mirror image rule says, under the common law, any change in the terms automatically terminates the offer. So if I were to accept with different terms, that wouldn't be a contract. The offer could be terminated by operation of law through lapse of time. The offer might be open for a specific period of time. Destruction or death, the destruction of the subject matter, death of the offeror or offeree, or even some what used to be legal, now illegal purpose for the contract. Acceptance is voluntary. It's made by the offeree. It shows their assent or agreement to the contract, and specifically the terms of that offer. This is the mirror image rule, that the acceptance mirrors the offer. Silence can be acceptance. In some cases, when the offeree has a duty to speak, he takes the benefit of services with the opportunity to reject and doesn't. That would be considered an acceptance, or that's the way the parties have done it in the past. In a bilateral contract, communication of the acceptance is necessary because of the mutual exchange of promises. Unilaterally, acceptance is evident because it's an action. You don't need to notify the other party. Instead, your notice is your performance of the act. In bilateral contracts, acceptance is timely if it's made before the offer is terminated. There's the mailbox rule, which basically says the acceptance is effective upon getting into the mail. Could be some issues with that. If the other party said the acceptance isn't effective until it actually gets to them. A party could specify how they want acceptance to be made. And in that case, then it wouldn't be an acceptance if it wasn't delivered in a way that was authorized. Could be online offers. If there is, then the seller's website should include a hyperlink to the full details of the offer. Here are some things to include pretty much in any contract, but this can be an issue in online contracts as well. How the other party would accept payment, return policy, a disclaimer concerning liability, a limit on the remedies that the other party can invoke if there's a breach of contract, privacy policy because you're potentially providing identifying information over the internet, and forum and choice of law clauses if there is a dispute, where it would be settled, as well as which law of which particular jurisdiction would apply. Click-on agreements. There's a binding contract when the party clicks on a box indicating they accept or agree. That could be through a website or software. The law doesn't require that the party actually read all the terms, just that they had access to the term. Courts generally enforce click-on agreements as well as shrink-wrap agreements. So you could have software inside of a box sealed up, and the parties agree by opening the box or installing the software to the terms. And basically, they don't necessarily see the terms in shrink-wrap agreement until afterwards. And the court reasons that they still would have an opportunity to reject it if they see the terms. Browse wrap terms. It says, unlike click-on agreements, browse wrap terms do not require assent and are usually unenforceable. What that means is that these are over the internet, and somebody would agree to terms, and if it's not possible for them to see what the terms their agreement is about beforehand, then the court typically doesn't enforce that. There's the e-sign law back in 2000. That gives e-signatures and e-documents legal force. So you can have documents that are electronic that would be the same as paper in terms of enforceability. For an e-signature to be enforceable, the contracting parties must have agreed to use e-signatures, and it doesn't apply to all documents. UETA, Uniform Electronic Transaction Act, its purpose is to remove barriers to forming electronic commerce, not create new types of contracts. An e-signature could be anything from electric sound symbol, process associated with a record. And a record is information that's inscribed on a tangible medium or stored in electronic or other medium that is retrievable in visual form. UETA doesn't create new rules, but rather it enforces real-world rules on electronic contracts. It only applies to e-records and e-signatures related to a transaction. It doesn't apply to wills or testamentary trust. And it doesn't apply unless each party has previously agreed to conduct electronic transactions. But that could be implied by the conduct of the parties or prior dealings. E-sign explicitly refers to UETA and provides that e-sign is preempted by state passing of UETA, but the state law must conform to minimum e-sign procedures. Looking at consideration, the second element, it must be something of legally sufficient value. It could be a promise, performance, or the promise to forbear, not do something. It has to be bargained for exchange. It provides the basis for the bargain, something that has legal value. As we mentioned, that promise has to be legally detrimental to the promisee or legally beneficial to the promisor. Court typically doesn't get involved in the adequacy or the amount of the consideration. It doesn't really protect people who enter into unwise contracts, pay too much for something, unless they determine that it's shockingly inadequate. This would be called unconscionability. Sometimes something sounds like consideration, but not really. If somebody had a pre-existing duty to do something, they can't promise to do it again for more consideration. There are some exceptions to that. Past consideration, if it was done for something that was already paid for. An illusory promise, it sounds like a promise. I promise to make a promise in the future. It uses the word promises, but it's really illusory. It could be settlement of claims. Accord and satisfaction is when you've got a creditor and debtor typically, and the creditor agrees to accept something different than the debtor originally promised to pay to discharge the debt. Could be a release, covenant not to sue. And then promissory estoppel, probably one of the hardest concepts in the chapter. When somebody makes a promise and the other party relies to their detriment, and justifiably relies, and that reliance is substantial, then the court would enforce that, even in situations where the parties don't have a contract. So that's the end of Chapter 7.